Hello and welcome. My name is Alan, and today we are going to finish off our series on the U.S. Constitution. Today we are doing the last three amendments 25, 26, and 27. So let's jump into this. 26 and 27 are fairly short, but 25 has got a bit of a length to it. Amendment 25. It was put into effect in 1967. Amendment 25, Section 1. In case of the removal of the President from office or of his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4. Whenever the Vice President and a majority of either the principal officers of the executive departments or of such other body of Congress as Congress may by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the power and duties of his office unless the Vice President and a majority of either the principal officers or the executive department or of such other body as Congress may by law provide transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers, the duties of his office. Whereupon Congress shall decide the issue, assembling within 48 hours for the purpose, if not in session. If the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. So yeah, that was a long amendment. Let's get into this amendment a bit. First, if you remember, there is information in the Constitution already on the ascension of the vice president to become president. Article 2, Section 1, Clause 6 of the Constitution. It reads that in case of the removal of the president from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president. I think they've got that wrong here, because that's not what I've got in my book as for Article 2, Section 1, Clause 6. Clause 6 in the book I've got is on pay. That'd be right here, Section 1. There's Clause 6, but in my book it's got the president shall at stated times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. So they've got something totally different in my book. Okay, it's actually Clause 5. They need to fix that. Regardless, also, as the rest of this goes, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president declaring officer shall then act as president, and such officer shall act accordingly until the disability be removed or a president shall be elected. So, that's the original of the Constitution, and then before that we read the 25th Amendment, which tries to clarify things. Now, the 25th Amendment just makes it more clear on the steps that shall be taken in such a case. Let's break this down a little further. Section 1 of Amendment 25, in case of the removal of the president from the office or of his death or resignation, the vice president shall become president. So again, that's the same thing we were seeing before with Article 2, Section 1, Clause 5. It's simply saying vice president becomes the president. Section 2, whenever there is a vacancy in the office of vice president, the president shall nominate a vice president who shall take office upon confirmation by majority vote of both houses of Congress. It basically says president can nominate a vice president if the vice president, whatever reason, death, resignation, or becoming president, that president can then nominate a vice president, which Congress has to agree to, of course. Section 3 is one that's considered to be used a few times. Whenever the president transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the vice president as acting president. So if the president decides there's going to be time that I am unable to discharge my powers and duties, they need to have the vice president be acting president until I am able to resume such a position. Now, Section 4 is also one that there's a lot of things about. This is a way that the president can be removed besides impeachment. It essentially is that there is a declaration by Vice President and cabinet members of the president's inability to discharge his duties in office, and thus the vice president should be put in charge as the acting president. It does require a two-thirds vote of houses of Congress. The vice president and the cabinet members can go. The president's unable to discharge his powers and duties. Congress can vote upon it, and if it's agreed by two-thirds majority by Congress, then the vice president takes over as acting president. But that is essentially what the 25th Amendment does. And there have been a number of times that before the actual amendment that this has caused issues. William Henry Harrison, early in the presidency, 1841, he actually died in office. And the idea, it had been suggested for the vice president to become acting president upon the death of the president. But Tyler asserted that he succeeded to the presidency, not just an acting president, since Harrison was dead. He tried to claim that since he had taken vice president oath, there was no need to take a presidential oath. But they eventually persuaded him to be formally sworn in to resolve any issues. But this would also have its effects with other presidents. Millard Fillmore in 1850, Andrew Johnson, who took over for Abraham Lincoln in 1865, Chester A. Arthur in 1881, Teddy Roosevelt, who took over for William McKinley in 1901, Calvin Coolidge in 1923, and Harry Truman, who took over for Franklin D. Roosevelt in 1945, and Lyndon Johnson in 1963, who took over for John F. Kennedy. Another big issue with this, besides just the succeeding of vice presidencies into the presidential position, in 1919, President Woodrow Wilson had a stroke, one of many he had had before, but no one officially assumed his powers and duties because it was actually kept a secret by his wife, Edith Wilson, and the White House physician, Carrie T. Grayson. And by the time it became public knowledge, only a few months remained in Woodrow Wilson's term, and congressional leaders just decided to the term go. But yeah, essentially, Edith Wilson was the secret president for a while, if you want to look at it that way. Of course, with the amendment taking place and finally being agreed upon in 1967, becoming law, part of the Constitution, it actually was in response to John F. Kennedy's death and Lyndon B. Johnson's ascension to the presidency. And it actually, the full first use of it was in the 1970s, 73, 74, thereabout, when Richard Nixon resigned. I know it was in his second term. I don't know exactly what year, but yeah, Richard Nixon resigns and his vice president, Gerald Ford, becomes president. Now, the other parts of it is also used or considered used by other presidents. Section 3, remember me talking about, the president can say he's unable to carry out his duties. Many presidents have considered invoking Section 3. Presidents like Jimmy Carter, Ronald Reagan, George H.W. Bush, Bill Clinton, and even Barack Obama. But they didn't actually invoke it. George H.W. Bush had to temporarily be the acting president after Reagan underwent a colonoscopy and was diagnosed with cancer. He was unsure if he'd make it through, so they went ahead and said that they may have to invoke Section 3, especially the White House counsel Fred Fielding and White House Chief of Staff Donald Regan. They actually recommended Reagan transfer the power. So George W. Bush became acting president for about 8 hours on the 12th of July, 1985. And we had other instances. Dick Cheney, who became president after Section 3 was invoked by George W. Bush, who was undergoing a colonoscopy. And then also in 2007, Dick Cheney again. Bush, it was before another colonoscopy. Section 4 has never been invoked, but has been considered. In 1981, following the Reagan assassination attempt, because they weren't sure how Reagan was going to pull through, but he did. He was able to resume his presidency. In 1987, there was also an issue with Reagan where he was showing signs of dementia, and he was officially diagnosed with Alzheimer's in 1994. But they let him finish out his presidency. 2017, when Trump fires James Comey, there was talks about invoking Section 4 of the 25th Amendment. And then 2021, when Trump and some followers stormed the Capitol. Well, not Trump himself, he didn't storm it, but their followers of Trump stormed the Capitol building. The idea of the 25th Amendment has been suggested to be used numerous times. So that is Amendment 25. Next one we want to look at is Amendment 26. This is a nice short one. It was put into place in 1971. Amendment 26, Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the U.S. or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. The right to vote for citizens who are 18. And part of the reason this comes up is the Vietnam War and the draft. You could be 18 and be conscripted into war. This is when they still drafted a lot of people, but you had to be 21 to vote. And there was a lot of pushback saying, look, you want me to go and fight when I can't even decide things? I have no voice. And there was even an attempt to do this by a bill in Congress through the Voting Rights Act. But the Supreme Court said, in the case of Oregon versus Mitchell, that Congress could not lower the voting age for state and local elections. And since there would be issues between having 18-year-olds who could vote nationally but be different in state and local elections, they decided to make it an act of the Constitution, an actual amendment. There were signs of this starting in 1941, people trying to bring the ability of 18-year-olds to vote as early as that. So it had been something that had been pushed for a while. And you have to remember, there's had to be a constitutional amendment for race and allowing people to vote, so you can't be blocked on account of race. a constitutional amendment that allows people to vote because you can't be blocked on sex, and now a constitutional amendment allowing people to vote because you can't be blocked on age. We've had issues with our voting issues, so yeah. Okay, so this will bring us to our final amendment of the Constitution to finish out this series. Amendment 27. It became part of the Constitution in 1992 and is the newest amendment. It reads, no law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. And believe it or not, this was actually supposed to be part of the Bill of Rights. It was actually proposed by James Madison. 10 of the amendments that Madison originally proposed became the actual Bill of Rights, but 2 were left out. This one was one of them. And 200 years later, the actual amendment resurfaces with wide public support. So what we have is that the idea behind the amendment is to reduce corruption in the legislative branch by requiring an election before a congressperson's salary increase takes effect. The public can thus remove members of Congress from office before their salaries increase. The actual amendment, according to Wikipedia here, was discovered by a student at the University of Texas at Austin, and it gained a huge public push. In fact, historically, states raised issues of congressional salaries during their debates on whether to ratify the Constitution. In essence, as far as I'm understanding it, the representative or the senator must undergo a term of at least a representative's length at the pay before any chance of an increase in salary. So if voters don't like them, they can remove them. And that's how I understand it. At least for myself. That's the way I see it. But that will finish our list of amendments. That will finish this series on the U.S. Constitution. I hope it helped you. You learned a little bit. But anyway, as always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. I will have my sources listed in the description below the video. I'll see you all in the next video. Until then, later.